Well, welcome to today's hopefully engaging interview with legal expert Milton Chappell. We're going to delve into the complex world of compulsory unionism and Janus rights and the rights of teachers in relation to workplace unionization. As I mentioned, our esteemed expert, Milton Chappell, will confidently navigate us through these topics, providing valuable insight and shedding light on the nuances that exist between private and public sector school teachers. And I hope you'll join us as we try to help you stay informed and empowered through this discussion. Let me give you a little background, very, very brief background on Milton's bio. He's been a staff attorney at the National Right to Work since 1976. He has a rich legal background, a long history of helping teachers and non-union teacher groups. Milton earned a law degree from Catholic University and a BA from Washington Adventist University, where he graduated cum laude. He's also admitted to practice law in Maryland, District of Columbia, and before the U.S. Supreme Court. Milton's also a member of the Federalist Society. Milton's long been recognized as a national expert who independent teacher groups and teachers turn to navigate through the schemes that teacher unions and legislators create when they try to impose compulsory unionism. Well, with that, I would like to bring in my guest, Milton Chappell.
Hi.
Milton.
How are you today, Don?
Good to see you, sir.
Thank you. Good to be here. So what problems do we have today? I'm a
Well, I thought the problems that we kind of already have and will have are basically understanding, first of all, the protections and the rights that employees have. So maybe we should start with generally some of the information that teachers need as far as when a labor union is telling them they need to do something, they have to do something. What are their rights? When can they say no? And when can't they? But let's begin by examining maybe the differences between public and private sector schools, including charter school models, and how employment arrangements in these particular sectors affect teachers' rights. Given that obviously a majority of teachers are in public schools, but let's go ahead and delve in right now just what teachers in those different school systems should know.
Okay, so let's deal with all three of those. There's public schools, there's private schools, and then there's charter schools. And the Janus decision, which established that public employees, so that would mean public school teachers, have a constitutional First Amendment right. Two things: not to join the union, not to be a member of the union, and not to have to pay any money to the union for any reason whatsoever. So even if a union is at their school district, again, I'm talking about public school teachers, and is, quote, representing them, or is the bargaining representative, the public school teachers have a constitutional right to have nothing to do with the union in the sense of they don't have to go to union meetings, they don't have to join them, they don't have to pay them any money. Okay? They have a right to do that as well. Our Constitution protects that. So they have the right to decide on their own how much association they want to have with a labor union. Now, let's switch to the private sector. The private sector does not have constitutional protections in the same way. So the First Amendment protects the American citizens from the authority and the power of the government along the lines of the protections given to our citizens in the First Amendment. The First Amendment does not, despite what you may hear in the news or comments or on X or social media, it does not protect you from private actors. And so private schools are a private actor, and their labor relations are covered by a different law, or are covered by the National Labor Relations Act. And under the National Labor Relations Act, if you are not in a right to work state, and I'll explain that in a minute, you can be required, if it's in the collective bargaining agreement, to pay a service fee to the union to cover the costs of collective bargaining. That service fee is less than union dues because unions perform more activities than just collective bargaining or representing employees through grievances or at the workplace. They are heavily involved in politics, ideological activities, and other activities having nothing to do with collective bargaining. So, in the private sector, a non member does not have to pay for those non bargaining political ideological activities the union undertakes um, in the private sector. Now, uh, even in the private sector, you have a statutory right. The National Labor Relations Act gives you the right not to join the union. You have the right to join and assist the union, and you have the right to not join and not assist the union. And the assisting has a small exception unless there is that clause in the collective bargaining to require you to pay money. Now, even if the clause or if they tell you that you have to join the union, you have to be a member of the union to keep your job, that is illegal. That violates the National Labor Relations Act. And you cannot legally be forced to be a union member. You can, however, if it's in the collective
Hey,
bargaining
Don,
agreement.
can we have what's the latest Institute brochure?
I'm getting feedback here, but anyway, can be required to pay the money. Now, right to work states are the states that have passed right to work laws that make it illegal to have that contractual provision. So, in right to work states, private teachers, private sector teachers are just like the Janus public sector. They do not have to belong to the union, nor do they have to pay any money to the union. Charter schools depend. Some charter schools come out on the side of being more like public schools, and therefore the public sector or the Janus decision applies. And other charter schools come more like private schools, and the National Labor Relations Act uh, applies. And while the courts and the National Labor Relations Board are still working out all the ground rules for making that decision, basically, if the private school is basically being run, the board are all private individuals. They're not being run by the public school board or by public officials. It's probably going to be considered a private school or under the National Labor Relations Act, private collective bargaining or labor relations. So that's kind of the overview there.
Okay, well, that's I think, from my point of view, clearly most teachers are in the public school system. I mean,
Correct.
overwhelmingly.
At least the
So,
ones that I've been representing for more than 40 years have pretty much all been around 99% at public schools, and the other 1 to 2% were at charter schools.
right, and even the charter schools, some can be public and some can be private, even if they're public. I mean, it's a little mixture there too. In the
Right.
it depends on the funding, I guess, how it's funded, right?
Well, it seems now to be more determinative not by the funding
The
because
management,
government still funds, but by the control, the
I see.
operating control
So if the
seems to
funds
be
go to a private, a nonprofit, maybe a private or a nonprofit that's private, even though it might be state funds, it doesn't matter as long as that nonprofit controls the school, and then it's
right.
considered private, right?
Now, that may change someday. The courts may come to or the board may come to a different way of determining whether it's more public or more private. So there are some situations. I believe Wisconsin is an example where under the state law, so each state sets up the rules for how a charter school can be established, how they're to run, the guidelines, the requirements, et cetera, et cetera. And so unless Wisconsin changed their law recently, their initial law basically required some government entity to establish and run a charter school.
Mm,
And so, because of that, they are viewed as basically public
I
entity.
see. Interesting.
But in many states, and I believe in most states, they have charter school. They allow private, public, basically anyone can set it up. But some of those charter school laws require or allow the charter school, even if set up and controlled by private individuals or private companies, they also, the public will fund part of the charter school expenses. So that's why funding starts to get looked at, because you may have heavy public funding, but the labor board and the courts seem to say we don't care about funding, we care about control. Who's controlling? Who's the real employer here? And so, unlike in most situations on the charter school, they don't seem to be following the money, but following who's giving the orders and who's controlling the employees and what they do and who are they reporting to.
All right, but now going back to of course, the public schools, obviously, they're all affected by Janus rights. And I can recall, listening to National Right to Work legal defense attorney Bill Messenger present his arguments and playing them back over and over, listening to all the stuff, and it seemed to go by so quickly that I'm not so sure it seemed that way to Bill at the time, but to me, I was like, that's hard. It's hardly enough time to present all the facts, but I guess it's all in the brief itself. And but in the end, I guess the Supreme Court essentially granted all public employees the right to work. And you probably want to elaborate a little bit on that, but the way I see it is that they can just say we don't have, even though we're still subject to your union control or monopoly control, we don't have to pay for the fees anymore, any fees. And so, Milton, if you could please explain the Supreme Court decision and the implications for Janus rights for all public employees, and I guess the advantages, and maybe if there's any pitfalls, what that might be.
Well, you are correct. At the end of the day, the Janus decision basically made all public employees, including public school teachers, have right to work freedoms, okay? Because it struck down any requirement to pay dues as a condition of employment or pay any money to a union as a condition of employment is unconstitutional. So the whole way that forced unionism works is that the employer makes it a condition of employment. The unions by themselves have no legal power, okay? They only are able to have this unbelievable power because the employer is either forced or voluntarily follows what they want done. So a union is not your employer, okay? So many times they seem to act like or think they are, but in legal reality, they're not your employer. So as a school teacher, you are employed by a school district, okay, a public school district. And you may have a union there and it may do all kinds of crazy things, but it's not your employer. So the union can run around and say, hey, I want you to pay me money. In fact, I demand that you pay me money. If you don't pay your money, you're not going to work here. But they have no legal power to carry that out. It's only when the employer comes and tells you, as a condition of employment, you must make this payment. And if you don't, I'm going to fire you. Okay? So the Supreme Court says the First Amendment says the government cannot abridge your free speech rights. Government cannot abridge your association rights, and government cannot tell you what political belief to believe or support. Okay? So then they said, what is government doing in the public sector when it's requiring employees to give money to a union? And the court said, wait a minute, anything in the public sector that a union does, whether it's giving contributions to political candidates, whether it's encouraging people to vote for a specific candidate, whether it is negotiating with the employer, now we're dealing with a public employer, the salaries or the benefits, it's all political activity because the government, its job is to collect taxes and do what it's supposed to do, what the Constitution, what the legal documents say. And so when a union or a government engages in collective bargaining with a union, it is end up discussing how those taxes are going to be spent. And if it agrees to more money being spent in a collective bargaining area, it has less money somewhere else. So at the end of the day, the majority in the Janus case said everything a union does in the public sector is political in the sense of the First Amendment, and therefore, government cannot force you to fund political activities. Okay, and so therefore, it violates your First Amendment right, and government cannot force you. And so, any attempt by government to require you to either be a member or to pay any money to the union has got to stop, and it's unconstitutional. Now, the unions can run around and try to get you to, quote, voluntarily pay money or join them, but they can no longer have the support and the power of government to force you to do that. So that's basically the kind of quick version, the Cliff Note version of the Janus decision, and the basis for it in finding that when a union, any collective bargaining activity it is doing, when it's sitting down with government, whether it's sitting down to negotiate a collective bargaining agreement, whether it's sitting down to process a grievance, anything that it's doing in the public sector affects the public will, affects the public money, and therefore it's political. It's not political necessarily in the way we think of Republican Democratic politics, but it's political in the broad sense of the word. And it's political in the sense of what the First Amendment gives us protections from the government doing to us.
Right. Well, when I was listening to you, and as I often do, it causes me to think about other things, and I got this thought. Don't give me a hard time. I'm totally wrong, but it sounds to me like if you're a principal or maybe the chairman of the school board or the city manager, you could say, "Well, we're going to agree to this contract, but we're not going to force our teachers to pay dues unless they want to." So they could literally say they could just not have compulsory dues in their agreements. Is that correct? So basically, that's something could be negotiated that every principal or every school board could do.
Well, they cannot legally, well, the Supreme Court seems to say that, and I don't agree with this, but the Supreme Court seems to say that you cannot enforce it. So it's possible, and I have seen this occur since Janus, that in collective bargaining agreements involving public teachers in various states,
Mhm.
the school district goes ahead and puts in the clause that says it is a condition of employment that you either join or pay money to the union. Okay. And the courts have refused to find that mere inclusion in the collective bargaining agreement illegal or a violation of the Constitution. What they say is a violation is if either the union or the school board, public employer, try to enforce that provision. Now, I disagree with that because having a misleading statement, actually an illegal, unconstitutional statement, will clearly confuse people. And I'm very concerned about people reading it and say, whoops, I've got to join. I have no choice here, when that's not true. And so, one of the purposes of the foundation is, in addition to providing free legal assistance, is to educate. And this is why we have these seminars. This is why we have the websites, to let people know no matter what anyone tells you, no matter what you read, as a public school teacher, you cannot be forced as a condition of your employment to either join or pay any money to a union. And if someone's telling you otherwise, if someone's putting pressure on you otherwise, call us immediately. Check the website out, fill out the form so that we can protect you.
So can the school also do the opposite and say, "Hey, we're not going to collect any dues, and it's up to you to get it, and we're not going to require it as part of an employment here anyway"? Or, I mean, I don't really.
So, So it gets a
You're going to
little.
have to go out and convince them to pay you, I guess, is what I'm saying. Could they, instead of being the collection agency for the union,
Well,
would they
well,
ever?
there's two things going on here at two levels. One is they cannot enforce and require you to pay it, or
Correct.
for them to collect it over your objection or without your consent. Now, the next level is, let's say you consent, and let's say you say, I want to join the union, and I know as a condition of joining a union, I must pay them dues in some cycle, annually, monthly, whatever. I could do it by writing them a check or Venmoing them or giving them my credit card or bank account. Or I could ask my employer, oh, it would be really easy for both me and the union for you just to take it out of my salary and ship it over. Okay. So I think you're asking about that last example that I
Right.
gave there. Could a public employer say, I'm not going to agree to that? And that depends on state law. Okay.
I see.
So first of all, let's move back to, if the public employer has not agreed to make that kind of deduction in the collective bargaining agreement, assuming it's legal, the public employer doesn't have to do it. Okay, and there's no basis for the employer to do it. So, first of all, you've got to have a provision in the collective bargaining agreement where the public employer says, if I get a voluntary dues deduction request, I will then honor that my employee has asked me to do, and I will act as a middleman to give that money to the union. Now, there were certain state laws that say that provision, that concept, we call it dues deduction or checkoff, is a mandatory subject of bargaining. And therefore, if the union asks for it, the public employee has to negotiate over it. He doesn't have to necessarily agree to it, but he can't just say, oh, no. There's got to be give and take, and there's got to be good faith bargaining. Do not ask me to explain good faith bargaining.
Well,
Uh,
that was my follow-up question. It's gone now.
yeah. Well, you just don't go there. It's the truth nightmare of that. It's whatever the labor board or the courts tell you after the fact. So if you do not give in to what the union asks. Now, if you always give in to what the union demands, you'll have no problem on good faith bargaining. Okay, I digress. So some states require you to bargain over it if the union brings it up. Some states don't say anything. Okay. In that situation, I would say a public employer school board would have no obligation to agree to it, even if the union brought it up. Okay. We also have some states that prohibit collective bargaining. South Carolina, North Carolina. There's some
Used to be
other.
Virginia. Yeah,
It used to be that way. There were some other states that are considering changing their law to do it. So
that's true.
this is another. I'm digressing a lot here. This is another falsehood that unions spread. The Supreme Court has ruled numerous times that the Constitution, the First Amendment, anywhere in the Constitution, does not include a constitutional right to collective bargaining. Unions would run around. We have a constitutional right to collective bargaining. You got to give us this. You can't say no. It is a statutory right. The Supreme Court has described it as a legislative gift, and they even said it is a very strange gift. It is a very hard to understand why the legislature would give away such power. Okay.
I bet I can come up with some reasons.
Yeah, well, we both can. And I believe the listeners can figure it out also. So we have, first of all, the states that say check off is a mandatory subject of bargaining. You're going to see them in most public sector collective bargaining agreements. And while a school board can say no, they have to do it in a certain way, and it's very difficult. We have other states that don't talk about collective bargaining or mandatory subjects of bargaining, or specifically limit bargaining to one or two matters. So therefore, checkoff is not in it if it's not listed. Wisconsin is one of those. So checkoff is not a mandatory subject of bargaining. And therefore, either they've said it's not or they haven't thrown it in. You have the school board having much more power to say no. And then we have a series of states who have said it is illegal. The public employer cannot deduct. I don't care if the collective bargaining says you can't agree to that. It's an illegal provision. I don't care that the employee comes and says, please, please, I want you to do it. Please help me. It's illegal. Okay. So your question about what can a school board do, it is my favorite, as I told you earlier this morning, my favorite answer. It all depends.
Okay. Well, let's go back to the private sector just a little bit. Now, my understanding is until really I guess it's 35, I think it was, the Wagner Act, the Supreme Court over and over and lower courts said, this forced unionism thing is unconstitutional, illegal. And then, of course, the switch in time to save nine speech that was the night before they heard the arguments of the Supreme Court about the Wagner Act. Lo and behold, a few months later, we ended up with the Wagner Act and forced unionism in the public and private sector. So, can you discuss a little bit about the impact of basically reversing decades of past decisions and imposing the Wagner Act on private sector employees, including teachers?
Well, obviously, the basic view of the courts prior to legislative action was that the employer basically got to make all these decisions. And any attempt by what either employees or what the courts felt were outsiders, they call them agitators, was illegal under the common law. It was an illegal conspiracy. There's other various legal terms and theories. And so a union's effort to force recognition or force an agreement was considered basically illegal. Now, at the same time, in a few situations, for whatever reason, there were a few employers that would agree to have a union there or would agree to give the union the power to go out and get the employees for them for whatever reason. And so, in that era of the common law, where I said the employer pretty much could decide whatever they wanted, you could have either you cannot be a member of the union, we won't hire you, or we will only hire members of the union. Okay. And in some cases, there were allegations that the union was really a tool of the employer. It wasn't the type of union we think of today. So there's all kinds of craziness going on before the statute came. But basically, as the Supreme Court, and as I mentioned earlier, the union's power to get involved and get in between the employee and the employer and to exercise and be involved in monopoly bargaining or collective bargaining, exclusive representation, all of that is a legislative gift. Okay, they don't have it outside of the legislature setting up rules, passing laws, and basically taking away from the employer their rights to decide these issues, and forcing the employer basically with a gun at their head to, number one, recognize a labor organization when certain statutory conditions have been met or the government certifies them, and forcing them into what's called good faith bargaining. And many of the laws go so far as if the employer doesn't, one of the penalties can be, and this one is shocking to me, one of the penalties can be that the government sets the contract and forces the employer to accept the terms that the government sets. So this is how bad the statute is and the only way that unions can work in it. So in my opinion, monopoly bargaining, collective bargaining, whatever you want to call it, only works by the government forcing private employers and public employers, when they pass laws that affect themselves, to give up their basic common law rights and have to do certain things. And these laws all start with the principle that the government favors collective bargaining, I'll use the terms that the law uses, as a way to resolve disputes between employees and their employer, or what many times the law calls labor and management. And so, because the law is basically saying it's a public policy of the United States to favor a collective bargaining resolution process, and has all these rules and regulations and everything else that we all are faced with today, and unfortunately have come way too familiar with, that's what the Wagner Act did. And that's what the Supreme Court did when it had initially said it was unconstitutional and then switched and said it was constitutional, and that the federal government did have this power under the Commerce Clause to force private employers to go into this model of hiring employees, working conditions, and how they deal with employees, and basically sharing that power with this outside group, or this group of employees, or whatever you want to call them, but what we call labor unions.
Well, it's interesting. The FDR at the time was an employer. Of course, he's a government employer, and he did not agree with public sector unionism at the time. As a matter of fact, he thought that their ability to have strikes and help public services and the taxpayers fund, and gave the union leaders a unique power to intimidate elected officials and government bureaucrats.
That's
That
yes,
it's not really available to any other citizen group out there. They can basically shut down
right,
a government where, the best you
right,
could do is stand outside and yell with your signs, or, go to a board meeting. But these people could literally just have the government shut down because they'd have everybody walk off the job. And so I don't want to get sidetracked on this, but since I'm thinking about that in the public strikes, which, you know, uh, what should,
well,
I'm thinking
let me
if you're a
just
public sector teacher and there's a strike, that you may not, agree. You're more focused on less, like a lot of teachers. I mean, I've heard people say it'd be better to settle these things during the 3 months we're not in school versus doing it during the middle of school and shutting things down. And a lot of teachers seem to feel that way because it disrupts their class. It messes up their own teaching and their program. So, what what rights do teachers have during a strike? Let's say, at first they just went ahead, as many teachers do when they first start there, they just say yes to whatever the NEA wants because, they got 3 years and they get tenure. They're not going to say no to anything. So so now they've got a strike coming around the corner, but they don't want to participate. What can they do, and what should they do? What kind of protections do they have, and what should they do to make sure that they are protected?
right. Good questions. Now, this one basically, the answer to this one basically has no distinction between private sector and public sector. Okay.
Hmm. Okay.
Um, it is true that in the private sector, basically, there are some procedures. There's exceptions to all general rules, but basically, in the private sector, strikes are legal. And some of them you have to go through a certain process to make them legal, but basically, strikes generally are legal. In the public sector, again, it depends by state, but certain states have said that public sector strikes are illegal no matter what. There's no way to hold a public sector strike, okay? That doesn't mean that strikes don't happen in those states that prohibit it, okay?
Can you give an example? Is there an
Laws
example
say
of a
that no
state?
one should. I'm sorry, what's your question?
Is there an example of a state where that you're referring to?
Yeah, Michigan is a great example. Michigan prohibits public sector strikes, but it occurs all the time. And part of the reason is that so when you have an illegal strike, when you have a statute that says it's illegal, okay, and it basically sets up that the school district has to go to court to get an injunction to stop the strike. Okay? Some school districts won't do it. Okay? Because, and this is one of the reasons that FDR was correct, that if, and I don't agree with this, but if somehow collective bargaining concept works in the private sector, it certainly doesn't work in the public sector. One of the reasons it certainly doesn't work in the public sector is that in the public sector, the union and the union members can elect the school board. They can basically choose and determine who's sitting across the table from them. The whole concept of that collective bargaining is a solution to potential problems or disagreements between employees and their employer is that you have two competing sides who have their own self-interest and that together they will compromise. In the public sector, if the union basically chooses who's sitting on the other side of the negotiating table, and those people are beholden to the union and not the taxpayer, there's no counterweight. Okay.
Right.
And therefore the union is the employer. It sits on both sides. So in Michigan, where I've had some experience, you have some school districts that won't do anything about the strike. Okay, so it may be illegal, but no one's enforcing it. So you can have all the laws you want on the books, and if there's not enforcement of them, they're not going to be followed. Okay. Other situations, you have the school board who is not totally controlled by the union, and they say, wait, this is illegal. We have a duty to teach the students. We need to be back in class. We need an injunction. We go to court. In Michigan, you have certain judges that won't do anything about it. And they will either enjoin with a very low fine or whatever. Now, having said all that, you also have good school boards and you have good judges that throw the book at the union. Okay. But even when a strike is illegal, the mechanism for enforcing it in most states is left to the school board. Now, let's get back to the question you asked me. What do teachers do, whether they're in the private sector or public sector? Now, when you become a member of the union, you may not know this, but you basically, when you sign that membership application form, you basically have signed a contract with the union. And all unions have a constitution and bylaws and internal operating documents. And even though you don't see it in most cases, the courts say that when you sign that membership application, it is the same as if all those documents have been presented to you like a contract. You read them all over, you agreed with them all, and you signed it. Okay? All of these contracts, all these union bylaws and stuff have what's called disciplinary power. The union takes upon itself the power to discipline members when they don't follow the rules that are outlined in the document. And so, obviously, the strike is a huge tool of a union to use in negotiation and to get what it wants. And therefore, all these bylaws, union bylaws, have in it as a member, if we have approved a strike, and it will have the way, and they're done in different ways, it will have the way that a strike gets approved or gets called. You have a legal obligation as a member to honor that strike, maybe to participate in that strike. And if you don't, if you violate it, we have the legal power enforceable in court to discipline you for violating the rules of a union member. So that sets up the number one rule. Your question was, what does a teacher do when a strike is called? They want to teach Johnny or Jane or their students and want to go ahead and cross the picket line and go to work. The school's staying open. Managers are trying to teach, etc. Number one rule, very important, applies in the public and private sector. If you are currently a union member at this point, you must resign before you cross the picket line. The union can legally discipline you for any action violating that strike for as long as you are a union member. The Supreme Court has held the union has no power over non-members. They have no legal disciplinary power over non-members. And so once you are a non-member, the union cannot subject you to union discipline. That doesn't mean they won't try, but the courts will not enforce that. Now, interestingly enough, what normally happens if you are a union member and you violate the strike rule, the discipline is usually 200 or more percent of what you earned while you were working during a strike. It's done for obvious reasons, okay? So you say, I'm not going to pay it. And you can't deduct it out of my pay because it's a fine. It's not union dues, so go have fun. The union can go and sue you in state court to collect that fine, and a court will enforce that fine, will give judgment to the union, in which the union can then go garnish your bank accounts, your wages, and have other deductions done, because the courts say you signed a contract and you also gave the union this disciplinary power over you. So, big thing, resign. Get that resignation to the union. There's a basic legal rule that says if you put it in the mail, the law assumes the union got it on the date it was mailed or the next day. We like to give a 24 to 48 hour window just to play safe. What's better is if you can take a witness with you and you hand it to a union official. But at the moment, either legally or factually, the union receives your resignation letter. You have resigned and they have lost their disciplinary power over you. Do you have further questions in that area?
No, it seems so. Basically, if you're a union member, you have two contracts. You have the contract with the school as an employee, and then you also have a contract with the union, you're basically saying. Where I guess a non-union member doesn't have but one contract, and that would be whatever this.
Right. And so, obviously, over my many years of representing probably thousands of teachers and other employees, there are a host of reasons why employees don't want to associate with a union. Okay. Some of them are this one. I just don't want to give power to another group. I want the freedom to make my decisions. Others are, I don't agree with what they're doing, or I heard about something they did. I really didn't have a problem with what they were doing before. All of a sudden, I learned they were doing X, and now I can't support that. Others have religious or moral or ethical reasons. The reasons are all over the map. But that's the point of the First Amendment. The First Amendment is that it gives the American citizen the individual right to make these determinations without government putting their thumb and forcing you or making the decision for you. Okay? And that's what the common law did before the Wagner Act came and messed it all up.
Right.
But the important thing here is that the individual right should be respected. And people, those who want to join a union, assuming it's legal, those who want to go out on strike, they have the right to do that, and they suffer the consequences of it. The consequences of it is that the company may go out of work and they may lose their job. The strike may work, the strike may not work. And even in the private sector, there are certain procedures in which, after a strike and after negotiations, an employer can legally declare the strike over and hire replacements, and you lose your job that way. So you can lose your job either because the strike drags on and the employer follows the rules in the statute for then being able to fire you or saying you either have to come back to work under my terms or you're no longer employed, or the employer maybe agrees to terms and then that bankrupts them or they go out of business or they move. But those are individual concerns that you should be able to make without someone telling you or holding the proverbial gun at your head.
So I guess the key is don't sign an agreement. It'd be the best thing if you don't have to. Then you don't have to worry about all those extra nuances. But also, if you have signed an agreement, you find out, let's say, like with the religious things, you find out your union is doing things that you totally are opposed to. There is a way to get out of it. You're not stuck in it. That would be resigning. And I was also wondering on the illegal strike, even if you're a union member and you decide, hey, not, I know the first lesson is just resign, but if you didn't resign and you said, this is an illegal strike, so I'm not going to walk out, can you still be punished for not walking out during an illegal strike?
That's a good question. I maintain that you have a defense from the union's lawsuit to collect that fine that they were requesting or you're being fined for following the law and not being illegal. But you never know what a judge is going to do.
Right.
Okay. So I do think it adds a potential defense for you, but I'd rather you resign. That's a much better way and not have to be betting on the whims of either a judge or a jury on this. So if the big thing, another thing I want to mention, and we do this all the time, and that's part of one of the reasons we do these interviews and these lunch breaks. If you're a union member and now you're having second thoughts, or you're saying, I think maybe I don't want to do this anymore, contact us. We can discuss it and we can walk you through what you need to do if you decide you want to leave the union. I'd much rather hear from you before than after and find out that you thought you were doing the right way, but the union was able to trip you up because something was done at the wrong time or who knows what. And then the other thing, the union's mode of operation is probably self-interest, but nevertheless, when you ask, I have employees that go up and say to the union, can I leave the union? Can I work here without being a union member? Can I do this, that, or the other? If the union doesn't want the employee to do that, they will tell the employee no. Okay? The answer may not be correct, but they don't mind. So if you're getting this, contact us and we will tell you the legal answer, the correct answer. For some reason, I have more experience with teachers, but many teachers, when they're told no, they don't investigate it further. They accept it at face value. Do not accept anything the union tells you at face value. Okay? They may be right, they may be wrong. Hey, you know what they say in the medical profession or the medical field? Get a second opinion. We are here to give you second opinions.
Well, so they asked the union president, and then they asked the union vice president. Both said no.
Yeah, well, I'm talking about an outside. That does remind me of a friend of mine that just recently was told to get a second opinion. I'm still shaking my head that my friend did this. He went and got a second opinion, but he got it in the same medical practice as the first doctor. You need a second opinion from an independent or different source. So going from the president to the vice president within the same union or even another union is not a second opinion.
All right. Well, I learn something every time I talk with you, Milton. I appreciate it, and I hope the people watching have also gained a lot of information, and at least they know where to go to. If for those seeking legal advice or assistance, you can go to National Right to Work Legal Defense Foundation's website, nrtw.org, and they'll be happy to get you on there. There is a place where you can, I think, a phone number you can call, or also you can fill out the form, and they'll get back to you.
Correct.
Either one of the attorneys or one of their assistants will get back to you with your to help you walk through it. Even I guess no question is a silly question. Is that
No,
correct?
no question is a silly question, and I'd rather you ask than not ask. Okay, and I tell all my clients if it crosses your mind, oh, should I find out this? Ask me. There's no such thing as a silly question. Okay, and I think this is posted on the CEAFU website, right?
Correct.
Yeah, I think there's a way you can contact CEAFU. So, I mean, anyone listening to this, whenever, feel free. If you just have a general question about your rights, just send it into CEAFU as well.
Right.
Maybe one of these times we'll go through just kind of questions we've had over the last year or something.
Sure. And if you've got some ideas about maybe other shows or other people we should be talking to besides Milton and some of our brilliant staff here, if there's some other groups out there that you think we should be talking with and exposing to people as well, let the Concerned Educators Against Forced Unionism know, and that you can contact us through more info at nrtw.org. That's MOREINFO, more info at nrtw.org, and that'll get it to us and to me, and then we'll try to get those guests on here as well, and try to get those that information out to other people as well. And Milton, thank you, and thank and I appreciate the viewers and the both current and future for watching this. And I guess goodbye for now, and we hope to see you all soon.
Okay, thanks everyone, and I look forward to answering your questions or discussing other relevant matters in the future. Thank you, Don.
Thanks again, Milton. Bye-bye.